The High Court, a poetic essay by CeLillianne Green. The High Court. Texas Law SB 8, September 1st effective date. The law practically makes abortion a crime. The words aid and abet come to mind. It is a law other states hope to imitate. From the date of fetal heartbeat, women cannot retreat. For these women, abortion is no longer a Texas option. In 40 weeks, there can be an adoption. No exception for rape, no allowance for incest. This law could only lead to women's rights protests. SB 8 limits a woman's autonomy, her voice. It encourages strangers to monitor a woman's choice. In Texas, women who choose to abort face a new attack. Like the Fugitive Slave Act, women can now be tracked. The Fugitive Slave Act of 1850 has been updated. In 2021, abortion bounty hunters have been created. The 1850 Act made slave catchers of nearly all. Abortion bounty hunters now answer a similar call. The call includes a $10,000 lawsuit incentive. Texas legislators have been painfully inventive. Catching women who choose to abort is a sinister form of sport. To win, abortion bounty hunters must sue in court. Abortion providers can be sued for what they do. A taxi driver, an insurer, a friend can aid and abet too. From a woman's last menstrual cycle up to 6 weeks, SB 8 is unclear if abortion bounty hunters can take a peek. Whole Woman's Health sought injunctive relief. Supreme Court denial was beyond belief. The High Court was in summer recess. This new anti-abortion law was certain to cause stress. SB 8 was a test for the new Supreme Court. How would it decide cases about women who abort? The High Court took the test and ignored the stress. In the shadow docket, around midnight, 5 Republican justices flexed their might. The majority did not need the Constitution to reach their conclusion. On procedure, the 5 justices chose to focus. Perhaps the Constitution vanished. Hocus pocus. Without briefs on the merits, without oral argument, in the shadow docket, the majority was content. No decision from a federal district court, no opinion from a circuit court of appeals. A mere 2 days of thinking about Texas Law SB 8. Less than a 2-page order issued in haste. 1 paragraph, a 5-4 decision, unsigned, lacking in legal precision. Barely any assessment of irreparable harm. Women forced to cancel abortions are most alarmed. Alarmed by a law where anyone can be in their shadow lurking. Alarmed by the anti-abortion lobbyists content and smirking. The High Court let stand SB 8. 5 justices decided justice could wait. As they enjoyed end of the summer leisure, Texas women feared abortion bounty hunter procedures. SB 8 is an anti-abortion enforcement scheme. It is a legislative nightmare more than a bad dream. Stunning, said Justice Sotomayor. She and 3 more dissent. Toward the Constitution, these 4 justices were bent. The majority made an end run around the United States Constitution. It was not a wise or just solution. Was the 5-4 decision really from America's highest court? Or was the High Court high? Could it have been mediocrity? Mediocrity of the most recent 3? Is the High Court too much of an intellectual demand? Perhaps the new justices simply did not understand. Precedent is not a suggestion. Law students learn about precedent in their first year. Supreme Court precedent should be clear. Roe v. Wade in 1973 holds the abortion rights key. Planned Parenthood v. Casey in 1992. Abortion rights reaffirmed and the precedent still holds true. Justice Kagan's dissent recognized Supreme Court precedent. The SB 8 conflict with Roe and Casey is undisputed. This fact cannot be refuted. The Texas law circumvents Supreme Court precedent. Surely Justices Thomas and Alito knew. The most recent 3 justices should have known too. It's possible the elderly 2 of the 5-member majority forgot. Thankfully, the U.S. Department of Justice has not. The Department of Justice understands the new Texas rule. Outsourcing state enforcement functions is unlawful and cruel. The Attorney for the United States has taken a constitutional stand. A case filed against Texas should reach the Supreme Court's hands. Until then, the 5-member majority can do what America needs: read, read, read. Read the amended United States Constitution. American courts use it for lawful dispute resolution. Read the 1850 Fugitive Slave Act. Compare the abortion bounty hunters to historical facts. Read Supreme Court precedents. Read the 4 justices' dissents. Perfection from the justices is not expected, but logic and reason should be easily detected. Regardless of how a justice became a Supreme Court selection, unconstitutional laws should be met with rejection. It is not enough to make a speech after the fact. A speech does not erase leaving SB 8 intact. In whatever political direction each justice bends, the Constitution is the framework on which the abortion rights depend. Abortion is a woman's medical decision with her doctor. She does not need to be watched by strangers or proctors. People with common sense are complaining. Confidence in the judiciary is waning. Is the High Court composed of partisan hacks? America is asking, watching, and keeping track. Much of America is now awake. The democracy experiment is at stake. For centuries, the experiment was premised on the most inhumane lie. For that inhumanity, America has slowly begun to grieve and to cry. At times, the High Court rulings seem to understand why. At times, trust in the High Court was high. However, public trust can become like dust, and with a gust of wind be blown away. Once blown away, trust which required centuries to earn will require equal time to return. Into the justice system, trust of the people needs to flow. Justice from the High Court can make it so. Justice does not oppress or cause the nation to regress. To regress to a pre-abortion rights days, the back alley maze, the unsafe coat hanger craze. The High Court can lead the nation out of its haze. This is what the High Court needs to know. Justice is the direction for trust to flow. The future is patiently awaiting its turn, watching to see America grow and learn. Learn from the past with sober reflection. Move into the future with introspection. America and the future have a date to meet. The democracy experiment is not yet complete. But the experiment cannot progress on the premise of a lie. Oppression and regression must be told goodbye. Otherwise, the people will pay a most high cost. The future of American democracy will be lost. The High Court, a poetic essay by CeLillianne Green. Copyright, October 2021.